Okay. Oh, sorry. If anyone would like to take photos, please come take them now. For any reason. 写真撮影は今やりたいんだったらやっていただけますか。
お願いします。ありがとうございました。
Okay. Testing. Okay. Welcome to the FCCJ. Today's topic is guilty until proven innocent, shaking up Japan's criminal justice system. I'm Jake Adelstein, a reporter with the Daily Beast, host of the podcast The Evaporated, and writer of Tokyo Vice. Today we have a wonderful group of people with us today to discuss Japan's criminal justice system. Very briefly, some opening remarks. As many of you are aware, once you are indicted in Japan, there is a 99% conviction rate. Part of that has to do with the fact that prosecutors drop about 50% of cases that are not slam dunks. But once you are indicted here, you are almost guaranteed to be convicted. And many people have described that system as a hostage justice system, a system that needs to be reformed. Today we have three distinguished guests that are going to be talking about that system. First is Saroop Ijaz from the Asian Division of Human Rights Watch. Human Rights Watch has just put out, as we speak, this report, Japan's Hostage Justice System, which you should be able to find online on their website. It's just come out today. They're just putting it out. It's a very long document about Japan's hostage justice system, and one of the reasons we have you here today. Please have a look at it at any time. We will try and put the link later in the FCCG webpage, and I'll tweet it out on my own Twitter account later. So first of all, we have Kana Sasakura, from the Faculty of Law at Konan University, the Executive Director of the Innocence Project Watch. Saroop Ijaz is the Counsel for the Human Rights Watch, which has long talked about the problems with Japan's hostage justice system, denial of bail, coerced confessions, and lack of access to lawyers. For those of you who aren't aware, if you are arrested in Japan, you can be held up to 23 days. You do not have the right to have your lawyer present while you're interrogated. Bail can be granted, but it often is not. Many people are held in jail until their trial begins. And then also we have with us Shinobu Yamagishi, who is the former president of a Tokyo stock listed company in the first division, the author of this book, Makehende. He was arrested for embezzlement by prosecutors in Osaka and held in custody for 248 days. He was eventually found not guilty of the charges. That not guilty verdict, even though it was, I think, was appealed, has held up. He's written a book about his experiences, and he tried to launch criminal charges against the prosecutors who forced him to make a confession to a crime he did not commit. The court recognized that his confession was coerced and not true. And his book also explains how someone can be coerced into confessing to a crime they didn't commit. And before I turn over the floor to Mr. Saroop, I would like to say I've been a reporter in Japan 30 years, and my first realization that the system here might be very unfair was covering the case of an English person who had been accused of smuggling. The Belgian police wanted to provide evidence to the Chiba prosecutors that they said could clear this individual of the crimes charged against him. His name is Nick Baker. The Chiba police, the Chiba prosecutors refused to accept that evidence. And after much pleading, I was able to have a talk with the Chiba prosecutors on the record. And I said to them, the Belgian police who are talking to me and have been trying to talk to you say that they have evidence which show that the man you you've indicted is innocent. Why won't you accept that evidence? And the prosecutor looked at me like I was an idiot, and he said, we have enough to convict him. Why would we want any evidence that would make us lose? And to me, that was the greatest evidence that this system here is not about winning. The system here is not about justice. The prosecutors are concerned about winning. And in fact, in books like Zetsubo no Saibansho, written by a former judge, when a prosecutor actually loses a case, they risk being sent to Aomori Prefecture or punished for actually failing to win what everyone else wins. And that's my own personal experience with the background of Japan's very warped hostage justice system. I will now turn the floor over to Mr. Saroop.
Thank you, Jake. Thank you, everybody, for attending. I'm very glad, delighted, and honored to be here and to talk about this, what Human Rights Watch thinks is very important work. Human Rights Watch has done this research over a period of 3.5 years, starting from January 2020, just before the pandemic hit. And the idea was to, as Jake has said, to deconstruct the 99%, the much lauded, famous, notorious 99% conviction rate of Japan. And not only to break it down, not only to, as Human Rights Watch says, to investigate, expose, and change, to not only investigate the research, to publish, but also to come up with a viable pathway forward for reform. Our findings, so for this research, what we tried to do was to get a cross-section of experiences and testimonies, in addition to international and domestic legal analysis, in 8 prefectures in Japan, interviewing people, again, from a wide range, from high-profile, white-collar crime accused to the shaken baby syndrome accused. And what we found is very similar to what I think the anecdote that Jake has just narrated captures it, what Professor Sasakura and others have said, that what we found is that prosecutors, on the prosecutor bit, I'll start from there, wield unaccountable and too much power, which in any functional, viable criminal rights-respecting criminal justice system is just fundamentally untenable. Trials are often ceremonies to enact verdicts of prosecutors. When we say hostage justice, of course, it's been said before, but the denial of due process, the denial of fair trial, the keeping people in custody, in prolonged detention up to the point that they confess is a form of coercion. We have tried to look at the reform attempts, 2004, 2009, and we've also tried to look at historical reasons for these institutional arrangements we find ourselves in. One finding that stands out is the weakness or the non-independence of judiciary, and vis-a-vis their vis-a-vis their power, vis-a-vis the prosecutors, and also a larger institutional culture, for want of a better word, of prosecutors, courts, investigators, everybody thinking that this is one team, as I think was saying that we won't look at evidence to the contrary. So what we have, as I said, the due process, denial of bail, we've tried to compare it with international standards. One reason for doing that, I think, and one thing that we hope would be persuasive when we make these recommendations to the Diet, to the Ministry of Justice, to the prosecution department, to the judiciary, is that Japan, Human Rights Watch does not give anyone a clean bill of health, any country. But Japan overall does fairly well on a human rights record. But this is a blind spot. This is an area of exceptionalism which persists after documentation of of the system's unfairness, of the system's inequities. And with the legal analysis, starting from changes which we propose, which we think should happen immediately, allowing lawyers to be present during interrogation, to have the right to remain silent, allowing bail unless there are very pressing reasons to the contrary, we documented cases where medical health, access to healthcare has been obstructed or impeded. And many of these recommendations that we have come up with, looking very carefully at the Japanese criminal justice system and the Japanese laws, at the international laws, at the Japanese constitutional framework, are meant to spur a reform attempt, and we really hope that at the level of principle they are unexceptionable, and we really hope the Japanese authorities would agree with us on that. But I'll be very glad to speak about the specifics of the report, of our research. As I said, it's a mix of finding testimonies of victims, of people who are facing criminal charges right now or who have faced criminal charges in the past, to speak to family members, to speak to lawyers, to speak to prosecutors. We wrote to the government in advance with our findings. So one hopes that they have also had a chance to read the report. But I'll stop with my summary of the report here. And again, I'm very grateful, very thankful to have had the opportunity to do this work and to come and speak to you. And I'll stop here because we have two very eminent panelists with us for their introductory remarks. Yes. Before we move to the rest of the discussion, I think we have a very brief video. We have a much longer version of it on the available on the website, but we'll do a very short 1-minute video, play the video, which will also give you an idea of some of our key concerns highlighted in the report.
勾留されますと最大で23日間起訴までの間身体を拘束されるということになります。この23日間が複数回繰り返されるということになります。
取り調べの場面というのは結局弁護人も立ち会わないで裁判官もいない検察官が一方的に尋問する場です。
今思えばそれが自白の強要なのかなって思って、要は怪してたことを揺さぶったような方に変換されて、
検察官が一旦起訴してしまえばその 99% 以上の事件が有罪になるという。
否認してました。一切がんについての治療は全くされませんでした。7回の保釈申請却下があり治療を受けられなかった。
初めて自分に負けたなと思ったのは自殺したいって真剣に思うようになって。
Okay.
We're turning forward to Ms. Sasakura.
Okay, thank you. Hello, my name is Kana Sasakura, and I teach criminal procedure law at Konan University in Kobe, Japan. I'm very delighted to be here and honored as well. My area of research is wrongful convictions and miscarriages of justice, and I also direct 2 projects focusing on redressing actual cases of wrongful convictions. One is Innocence Project Japan, and the other is Shaken Baby Syndrome Review Project Japan. So it has been my great honor to have had a chance to work with Human Rights Watch on their very important project on the hostage justice system in Japan. I've been working with them for 3 years, for the past 3 years, and I had a great opportunity to review the report as well. So I am the executive director of the Innocence Project Japan, which is based in Kyoto. IPJ is dedicated to redressing cases of wrongful convictions and accusations. So we have about 40 members who are also experts, including attorneys who all work pro bono. And also we receive applications, and also we have about more than 250 student volunteers as well. And we receive applications from all over Japan and have received more than 500 letters in the last 7 years. We have been successful in getting 2 acquittals since our launch in 2016, and now assisting and advocating 4 cases. So as Saroop described, and Mr. Yamagishi will explain to you from his expertise and experience, hostage justice contributes to wrongful convictions in Japan. I am not going to repeat what they will be, and they have already described in detail. But as I show on this slide, I think the major cause of wrongful convictions in Japan is false confession. And why are there false confessions? Because the focus of investigation in Japan is to get suspects' confessions. The hostage justice is used to get a confession. So long detention of suspects and defendants, sometimes with a ban to communicate with their families and loved ones, compulsory interrogations, even when the suspect chooses to remain silent, or denial bail. And Mr. Yamagishi will be explaining his experience about this hostage justice system. So this slide shows a list of cases which were exonerated in Japan through retrial. When we look at how many of these cases were with false confessions, it's here. The cases listed in red are cases with false confessions. So that's 21 out of 25 cases were with false confessions and later exonerated. So the evidence is clear that false confessions leads to miscarriages of justice or wrongful convictions, and also the hostage justice system contributes to these wrongful convictions. So one case, a very famous case of false confession, which you might all know, is the case of Iwao Hakamada, whose retrial was granted and about to start. This was a case of a death penalty. So Hakamada was a death row inmate. And so Hakamada made a false confession because of brutal and lengthy interrogations. This case illustrates the serious consequences that the hostage justice brings. So Human Rights' new report that was just released about 10 minutes ago, I guess, will be is important and will be a monumental report in the history of criminal justice in Japan. However, we must see that its recommendations are implemented and a reform of the criminal justice system is done. So therefore, we are announcing today that Innocence Project Japan and Human Rights Watch will be launching a 2 or 3 year-long campaign to fight against the hostage justice in Japan and to reform the system. So we will be conducting further research and holding educational events. And our first event will be held on June 30th in Osaka this year. So that's about a month later. We have Mr. Yamazaki as a speaker, and also Mr. Kana, who's sitting over there, the director of Human Rights Watch in Japan. We invite all of you to this event and to our campaign. We need to make a change and bring the Japanese system to a global standard. And please do not forget that the system impacts not only the Japanese citizens, but the people who are living in Japan, the foreign citizens who are living in Japan, especially the people who are accused of white-collar crimes. This will impact all of the people. So thank you for this opportunity to speak today. And with that, I conclude my speech. Thank you.
We're about to turn the floor over to Mr. Yamagishi. Very briefly, his case is complicated, but the essence of it, he was arrested in 2019 on suspicion of embezzling 2.1 billion yen, about $17 million, from a school operator called Meijo Gakuin in Osaka Prefecture. He was held for about 250 days, not granted bail. During that time, he was coerced into making a confession. The confession was later thrown out. He was found not guilty. That was held up in further rulings. He later tried to launch criminal charges against the prosecutors for violating a law which says the prosecutors cannot threaten witnesses. He has written a book about his experiences. Because we need to leave time for questions and answers, we're going to give him about 5 minutes, and then we'll start taking questions from the audience. Mr. Yamagishi-san?
はい。日本語でいいですか。ただいま紹介いただきました山岸と申します。令和元年ですね、12月に21億円の業務上横領事件に関与したと、共謀をしたということで、全く身に覚えのないことで、いきなり逮捕されました。そして、12月に逮捕されまして、そこから248日間、令和何年かな、2年の8月まで、大阪拘置所で勾留されてました。
山岸さん、ちょっと待ってください。通訳さん。
Thank you very much for your kind introduction. My name is Yamagishi. In December 2019, I was all of a sudden arrested and for the alleged crime that I colluded over a corporate embezzlement scandal involving 2.1 billion yen. And since my arrest, I had been detained for 248 days until August of 2020.
はい。そして、令和3年の10月に、無罪の判決をいただきまして、そして、検察庁大阪地検特捜部は控訴すらできずに控訴も断念して無罪が確定しました。当時特に勾留されてた時はめちゃくちゃ辛かったですけれども、今はですね、大変幸せに、人生最大に幸せに暮らしております。
In October 2021, the court acquitted me, and the Osaka District Prosecutor's Office, Public Prosecutor's Office, even dropped the appeal, and I was confirmed innocent as a result. During my detention, I had to say that I was mentally anguished. However, I cannot. Right now, I am living a very happy life, and I cannot be happier than now.
その時の経験なんですけど、今から思えば誰も経験できないような大変貴重な経験をしたかなというふうに思ってます。経験があることによって私はやっぱり賢くなりましたし、で大変強くなったと思います。もう今後この人生で何かまた壁が僕の前にはだかったとしても絶対に解決できると、絶対に負けないというような自信もつきました。ですから今となったら大変いい経験になったかなと思ってます。ただ先ほどからお話が出てますように、起訴されれば 99.9% 有罪になるというのが日本の司法というふうに、先ほどからおっしゃられてますけれども、あんなに世間知らずの検察官があんなにずさんな捜査をしてなぜ 99% 有罪になるのか、私には理解ができません。
山口さん、ありがとうございます。通訳さん。
Looking back my detention period, looking back right now, I think that I learned a very precious experience through my detention period because I became much wiser and stronger as a result of my detention. And I feel that I can overcome any hurdle from now on right now because I gained this precious experience during my detention. So looking back, I had a precious experience. Having said that, though, it's been pointed out that Japan's justice system can convict at 99.9% of all the persecuted cases, and that is truly unbelievable for me because the prosecutors know nothing about the real world, about the business, and they conduct a very poor investigation. And why it cannot make sense to me that why the prosecutors successfully convict 99.9% of cases that are prosecuted.
山口さんありがとうございます。時間の関係でちょっと質疑を開始しますので、
わかりました。
よろしくお願いします。山口さん後で個人対応できますか？後でなんか記者に対応できますか？
はい。
Okay. We're going to take questions now because of time, but after we're done, if anyone would like to speak to Mr. Yamagishi one-to-one, he will be available for some time. We'll try and set up a place where we can talk to him, or maybe it'll be in the cafeteria. So I'd like to open the floor to questions. Usually it's to the working press first. Anyone who has a question, please raise your hand, and when you take the mic, please identify yourself. Any questions?
John Boyd, maybe I should take it out.
Yeah, sorry about that.
John Boyd, freelance writer. I have a number of nitty-gritty questions, so I'm hoping you can help me here.
Could I ask you to limit it to two questions at first? Just so that others will have a chance?
Right. I understand. When is the lawyer? What is the minimum time that a lawyer is allowed to talk with a defendant? What is the minimum time? Like how many days after he is held in detention?
はい、勾留されて弁護士の方が立ち会いを許されるのは何日間なんでしょうか。
So, in terms of the lawyer's minimum time, you mean how soon is the lawyer allowed to talk to the defendant after arrest, or for how long? Is the question for how soon after somebody is arrested is their lawyer allowed to talk to them?
Yes.
Okay. So, in terms of the law, the Japanese law allows for 23 days of arrest before, and under one charge, and that can be prolonged. And lawyers can speak to defendants during that time. But where lawyers are not allowed to be present, which we find is a critical thing, is during interrogation. So there is access to a lawyer, while the access to everybody else can be barred through a communication prohibition order, but lawyers are not allowed to accompany defendants during interrogation, and that's something that we feel needs to change.
Could I have a
Yeah,
follow-up
of course.
In the case of a foreigner being a defendant, how would he or she contact a lawyer while being held in detention?
We have documented in this report as well cases of foreigners who face criminal charges, and they can access a lawyer in that sense through the embassy. They're allowed access to the embassy if it's
through a phone call.
Through phone call, yes,
Oh,
they're
okay.
allowed. But and they can, of course, depending on who the foreigner is and how well the system, they can get a lawyer for themselves. But as I said, there is no blanket prohibition to not having a lawyer. But on critical points, when you need a lawyer, particularly in a system where there is no right to remain silent, that could be a problem. Okay. And that is a problem, and we hope that would change urgently.
I'd like to follow up, because I think this is also part of his question, is how many minutes a day are you allowed to converse with your lawyer? Do the prosecutors decide how many minutes that is? Is there a limit? Can you talk to your lawyer every day if you want to?
I'm not aware of a limit. So you can talk to your lawyer. But yes, prosecutors, we have found cases where prosecutors can impede or investigators can impede because if you are under investigation or under interrogation, for that period your lawyer can't speak to you. And there are cases where people are under interrogation, so to speak, for very long stretches during the day.
Yes, please.
Tim Horniak, freelance. I have a question for Yamagishi-san. We've heard a lot of reports about what it's like to be detained in Japan. Detainees have to sit down or kneel all day virtually on tatami mat or some place like that. Could you tell us a little bit about your experience being detained, what it was like on a daily basis, and would you describe that as a form of torture?
はい、たくさんの交流中された方のその交流中の生活の様子というのを拝見しておりまして、例えば畳の敷かれた独居房のようなところに膝をついて座るとか、そのようにして一日中過ごさなければならないという生活の様子というのは、見聞きしているんですけれども、ご自身の交流生活というのはどのようなものでしたか。そしてそれは一種拷問のようなものだったんでしょうか。
いや、拷問はないです。はい。ただ何もしてはいけないんですよ。私は体を鍛えるの好きですけれども、そのトレーニングすら決められた時間1日30分しかできない。
Well, there was no torture being imposed on me. However, we were not allowed to do anything. I'd like physical exercise, but I was only allowed to do so for 30 minutes a day.
そして夕方6時までは寝転ぶこともダメです。で、むやみに立つこともダメです。ずっと座ってなさいって言われます。
I was only able to sit down during the day until 6 p.m. I was not supposed to get up or stand up or even lie down.
結局何ができるかというと、具体的には字を読むことと字を書くことしかやることがないという248日間です。
So during the 248 days, I was only able to read or write.
Follow-up question. When you're in detention, how many times a week do you get to take a bath? Do you get to choose what you read, and are you forced to sit in seiza? Also, those 3 questions.
1週間の間にどのぐらい何日くらい入浴することができたんですか。そして
2回です。
I was only allowed to
1回あたり15分です。
take a bath twice a week and only 15 minutes each. 正座を強要された。いや、正
座でなくてもいいです。別にあぐらかいててもいいです。座ってなさいということです。
I was instructed to sit down. It doesn't have to be a seiza form. It didn't. And what was the third question?
What reading materials were they provided?
読書の本というのは支給されたものだったんでしょうか。
いやいや、差し入れが来ます。友人とか家族から。
My friends and family members gave me books or handed me books to read.
I've heard that it's very hard to sleep at night. What are the conditions? Would you sleep where the lights have to be on? Can you close your eyes? What's the deal with that?
夜眠る時の条件も非常に厳しいと聞いているんですけども、例えば照明はつけたままでいけないとか、目を閉じてはいけないとか、何かそのような厳しい条件というのはあったんでしょうか。
照明は寝る時もつけたままです。
The lights had to be on.
はい。で、9時を過ぎれば、読書もしてはいけないです。
And we weren't supposed to read even after 9 p.m. at night.
はい。で、起床が7時半です。
And we were instructed to get up at 7:30 in the morning.
冬の間はいいんですけれども、夏になれば4時半ぐらいから明るくなりますので、本当に寝られないんですよね。
So I had a hard time sleeping, especially during the summer, because at 4:30 in Japan, the sun is out, so it was hard for me to fall asleep during the morning hours or late early mornings in the summer.
で、4時半に目が覚めてしまえば7時半まで、また動き回ったら怒られるんですよ。 ずーっと布団の中にとかないといけないんですよ。
And I forced myself to keep myself in the futon mattress during the 3 hour between 4:30 when the sun is out and 7:30 when we were supposed to get up.
Any other questions? Please, sir.
I'm William Horsley, visiting from London and Sheffield. I'm a former BBC man here in Tokyo, and I represent the Centre for Freedom of the Media at University of Sheffield, which does work with the UN on the issue particularly of safety of journalists, freedom of expression, but also the issue of impunity. And I'd like to, if I may, a quick comment, Mr. Chair. It does seem to me, coming from the UK, that Japan is a blind spot in the international discussion, which is now very much focused on the role of in an open society of freedom of information, freedom of expression, and media freedom as a means of giving effect to all fundamental rights, including that of access to justice and political rights. So my question is about the strategy and direction detail of your reform proposals, both inside Japan, where I note that the Japan Bar Association has been highly critical of many issues to do with Japanese lawmaking, the secrets bill, also the Carlos Ghosn affair, and so on, and internationally, because, again, Japan has just hosted the G7. This is all about the rule of law as well as international peace. And again, what is striking to me is the lack of any public debate and understanding of the extent of the importance, the denial of these rights in a systemic way, as is described in your human rights report. So I wonder whether any of these international bodies, the treaty body of the International Covenant for Civil and Political Rights, for example, the International Commission of Jurists at the international level, are these being helpful to you? I'd like to talk to people separately because my University of Sheffield body, we are talking about the weaponization of law and freedom of expression. It does seem to me that there is an overlap. But secondly, on the domestic side, public education, on the issue of the rules of the profession. I mean, Britain also has problems with some of its domestic law, and the issue, for example, on slaps, on defamation law, is to reform the legal profession. So again, there seems to me that information from outside, models of reform from outside, may be very, very helpful to Japan. I wonder what you think.
No, I mean, on the larger Japan question, I am not an expert on Japan. I'm not the Human Rights Watch expert on Japan, so I can't comment on the larger Japan question. But on this report in particular, on this issue, we have made recommendations to the Japanese government. Firstly, as what you refer to the International Covenant on Civil and Political Rights, we have made a recommendation in this report for the Japanese government to sign and ratify the optional protocol. We have made a recommendation that the Japanese government should sign and ratify the optional protocol on the Convention Against Torture, Cruel, Inhuman, and Degrading Treatment. So, in terms of the UN system, and we've devoted a section, a chapter in the report, looking at Japan's compliance, particularly laws as they pertain to the criminal justice system, their compliance with international standards, standards as laid down in the International Covenant on Civil and Political Rights, Convention Against Torture, in various other UN guidelines on prosecutors, on independence of judiciary, and looking at looking at interrogation practices, communication bans, access to counsel, and what we do hope that there would be international spotlight on it, but also that credible, robust voices within Japan would, I think, be very important interlocutors, perhaps more important than most other countries that Human Rights Watch works in terms of a meaningful, viable reform attempt, particularly a large reform attempt. And as I said, we've sent this to the government, and we hope that there are people within with parliamentarians, civil society, who agree with these findings, who want change, who want a reform, and that is what we are hoping.
Can I add
Yes,
some
please,
more?
please.
So I'm going to talk in Japanese. 日本に対しては国際社会から、この特に刑事司法の問題についてはですね、多くの批判があると思いますが、今まで日本のその法務省であったり、あるいは政府はその意見に対して日本の刑事司法は基本的にはうまくいっているという、考え方を取ってきた、そういう対応を取ってきたと思います。
Well, there has been a mounting pressure from the international community on the Japan's criminal justice system, but MOJ Ministry of Justice kept insisting that the Japanese justice system is functioning very well.
例えば法務省は最近この人質司法の問題について、国際社会から多くの批判が寄せられたことに対して、Q&A をですね公表して、その中でも同じようにですね基本的に日本の刑事司法はうまくいっているという立場を取ってきました。でこの Q&A についてはぜひですねホームページを見ていただきたいと思います。
Ministry of Justice, for example, recently released a QA or frequently asked question and answer session on their homepage, and I hope you have a look at your free time. And that it maintains their contention that the Japanese criminal justice system is functioning, even though the hostage justice system is facing a barrage of criticism internationally.
ただし、やはり国際社会から批判のある通り、国際基準に照らして問題がある点が多いということはですね、明らかではないかと思います。で、この日本の刑事司法の問題は、日本人だけではなくて、日本に住んでいる例えばビジネスマンであったり、あるいは日本に来ようとしているけれども、こういう刑事司法のある国だったら来たくないと言っているビジネスマンだったり、そういう人たちにも影響を与えていて、ひいては日本の国益といったものにもですね、影響を与えているのではないかと思います。
However, it is quite evident that the current Japan's judicial system or justice system is inconsistent with the other international standards. And this justice system is relevant not only to the Japanese citizens, but also foreign expats who are being assigned to work in Japan currently, and prospective future foreign workers who are considering working in Japan but hesitate to come to Japan because of the dysfunctional justice system. And this works to the detriment of Japan's interest.
従いまして、日本の例えば国会議員であったり、あるいはビジネス界の方々であったり、あるいはその他ですね、国際社会とのつながりをですね、いろいろ持っている方もですね、含めて、メディアを含めてですけれども、こういう問題について発信してですね、何が日本のですね、社会にとって不利益になっているのかということをですね、もう少しですね、強く社会に訴えていくことによって、日本の在り方というのも徐々に変わっていくのではないかというふうに期待しています。
And it is our hope to put pressure on the Japanese society to change this justice system. And I hope that lawmakers in Japan and also those in business circles, as well as those in the media and others who are well connected internationally, will disseminate the issues pertaining to the Japan's justice system going forward, and highlighting that the disadvantages caused by the system, the current system. That is our intention.
Sasakura-san. On the Ministry of Justice's homepage, are there any particular passages that are worthy of particular ridicule? Because they seem to say amazing things.
Yeah, actually, it does say some amazing things. So, there's a question on the Japanese interrogations. So the Q&A says that in Japan, I quote, "In Japan, various measures are taken to ensure interrogation is conducted properly and lawfully. So issues including whether to allow the presence of lawyers during interrogations were discussed for nearly 3 years at the Legislative Council. During the discussion, some council members expressed concern that if lawyers' attendance during interrogations were to be granted, it would make it difficult to discover the truth of the case due to the difficulty of obtaining sufficient statements from the suspects, which would significantly undermine the function of interrogation." So this might strike us amazing.
Yeah, the Ministry of Justice is one of the best stand-up comics in Japan these days. Are there any other questions? Please identify yourself and your news organization when you speak. Thank you.
Takuya Nishimura with Hokkaido Shimbun Press. Thank you very much for the press conference. I would like to ask you about the percentage of the criminal conviction rate. The paper say about 99% is the number of the rate. What do you think is the proper rate of the criminal conviction rate? What do you think, what kind of change or what kind of law or amendment is needed in the Japanese prosecuting system? And what is the alternative of the current system?
Okay, so just to make sure, 3 questions. What do you think is the proper percentage of convictions? What should be improved to the system? Those 2 main questions?
Yeah.
Okay.
Thank you. I think you're right. The conviction rate, and when we say is above 99%, in 2020 I think it's 99.4%. We cited that in the report. Important to clarify when we say, as Jake did in his opening remarks, this is the percentage of cases that go to trial where there is an indictment. In terms of what needs to change in the criminal justice system, it is the entire exercise, the entire report, and Human Rights Watch's entire research is an attempt to providing that roadmap. We made recommendations, as I said, to the Diet, to the courts, to the prosecution, ranging from specific amendments in the criminal procedure code to larger amendments which require greater political will in making, as I said, the prosecution more accountable, the judiciary more independent. And also as this to guarantee, why I think an important way of how we can frame look at it is to guarantee the presumption of innocence, given that this was also the name of this press talk. So of being presumed innocent until proven guilty, rather than the other way around. So that's one way of looking at. And what that would entail in practice is, as I said, it would entail a change in laws, a change in attitudes, a change in policies at all levels, at the level, all components of the criminal justice system, at the level of the investigation, at the level of the prosecution, at the level of the adjudication, the court. And as far as specifics, of course, there is a paucity of time. We have made several recommendations, but I'll stop here and Professor Sasakura.
はい、ありがとうございます。99.8%、9% の有罪率は何を物語っているかというと、結局のところ検察官が起訴をする前に事件が有罪であるか無罪であるかということを自分たちで判断し、そして有罪が確実であると考えた事件のみしか起訴しないということになります。つまりこの数字というのは検察官が実際には裁判をしているということで、この事象をですね、この現象をですね、検察官司法というふうにもですね、批判されてきたわけです。
Well, what does it mean to have the conviction rate of 99.8% or 99.9%? It is actually expressed as the prosecutors conducting a trial on behalf of the judicial part of the powers, because 99.9% of the cases were prosecuted, the prosecutors decide whether or not the accused are convicted or not prior to the trial. And if they are convinced, they only go to the court. So it is, in a sense, the prosecutors are giving the trial process by themselves. That is why it's been criticized like that.
で本来の在り方は公判定で、ことを決するということであって、その起訴の段階であるいは捜査の段階で ことを決するということではないはずなんですね。つまり公判中心主義というですね、公判が中心にあるべきだという考え方を貫徹することが必要だと思います。で、そのためにはですね、一定程度基礎の基準というのを下げる必要というのはあると思います。
So in a sense, we need to lower the hurdle of prosecution in a sense, so that ideally we'd like to have a trial-centered based, trial-based system where the ruling should be handed down by the judges, not by the prosecutors during the process of investigation.
そして公開性が確保されている公判定の場でですね、すべてを決するということがあるべきですし、また逆にですね、間違ってしまった事件、つまり冤罪の事件についてはですね、しっかりと後で検証して、過ちをですね認めて、そしてですね問題点を刑事司法の問題点を解決していくと、解消していくというようなですねシステムも必要ではないかと思います。
So we should decide everything in a trial-based manner, in an open and honest manner, which is based on the trial basis. And then if a miscarriage of justice happens, then the prosecutors should rebuild the process and admit their mistakes to rectify their problems. So we need to reform the criminal justice system accordingly.
現在のシステムにおいては、検察官が一旦起訴をすると有罪判決に固執をすると、そして徹底的にですね有罪をですね追及してしまうというようなことが行われています。それは山岸さんの事件でも同じことが起こりましたし、山岸さんは本の中で引き返す勇気というのが必要だというふうに強調しておられますが、まさにその通りだと思います。
Well, Yamagishi-san described in his book that it is important to have courage to return or go back to your basic, go back to where you were. And that's an important message to the prosecutors because currently, under the current justice system, prosecutors pursue conviction after prosecuting cases, and they stick with the conviction or winning the case by themselves.
だからこういった基礎の在り方というのをですね根本的に変えるためには、基礎の基準をある程度は下げるということはですね致し方がないのかもしれませんし、その基礎についてですねそこでもう判断がもう有罪であるということが確定するのではなくて、もちろん判決が出た時ですから、それをですね社会もですね容認するということがある程度は必要なのではないかと思いますし、この点はですね以前から研究者がですね主張してきたことでもあるかなと思います。
はい、ありがとうございます。
Academics have pointed out the fact that the prosecution level should be lowered, or a hurdle should be lowered in order to have a better justice system where the ruling of conviction is handed down through the process of trial, and the decision made by the court should be accepted by the society in that way.
We're going to take 2 more questions, and then we'll have to adjourn the meeting, and afterwards you're more than welcome to talk to the individuals. I'd just like to point out that during the Carlos Ghosn case, when he escaped from Japan, when Masako Mori, who was the Minister of Justice, was asked to rebutting the criticism of Japan's hostage justice system, she essentially said, well, you know, Japan is presumed guilty until proven innocent, and he should stay in Japan and prove his innocence in court, which was a wonderful gaffe that reveals that really does how justice works in Japan. And in question to the Hokkaido Shimbun, question about what is an acceptable level, I don't know what an acceptable level is, but at a time when Japan had a jury system, according to legal scholars, the conviction rate was about 80%. So we'll take 1 more question from you, and then after that, who else would like to ask a question? Because we have time for 1 more.
Just following question in Japanese.
Okay, Tim, you're after him.
基礎の基準を下げるためには刑事訴訟法の改正で可能ですか？それはどこをどう変えれば可能ですか？
How should we amend the code of criminal procedure in order to lower the hurdle of prosecution? That is my question.
その点についてはもちろん刑事訴訟法の改正までは必要がなく、運用の改正ということになります。つまり起訴裁量のですね行使の在り方を変えていくということになります。ただしこれは起訴を増やせばいいというふうに申し上げているわけではなくてですね、その本当の主戦場を公判に移すためには何を変えるべきかという点をですねお話ししているのであって、でもちろんですけれども全体のですね裁判の在り方、司法の在り方そのものを変えるということをですねが必要だというような主張になります。
Our contention is that we should drastically reform the justice system itself as to how the court, to indicate or to better identify the court to be the main battlefield for the accused and the prosecutors fight each other, because that should be the basis of the handing or justice. And therefore, we are not demanding the code of criminal procedure to be amended. We only advocate the operational side to be amended.
If I may add, just to add, we do in the report talk about the Code of Criminal Procedure, and as Professor Sasakura has said, the misuse of it. I can give you an example, Article 89, subsection 4, which talks about the denial of bail on the grounds that the defendant will, if the bail is granted, may conceal or destroy evidence. And that is used as a blanket reason to deny bail in a very large number of cases. So it is the misuse of the Article 89, subsection 4. In certain cases, the language can be more precise. So it's not easy to misuse. It's not open to discretion. So that's just as an example of when we talk about individual articles of the Code of Criminal Procedure.
Last question, Tim.
It's another question for Yamagishi-san. Briefly, what are your top tips for surviving detention in Japan and navigating the judicial process?
勾留期間中ですとか、その司法のその過程を生き延びるための手がかりといいますか、アドバイスがあれば教えていただけますでしょうか。どのようにしてその勾留期間や公判中を耐え忍んでいらっしゃいましたでしょうか。
いや、心が折れないことです。
I would say never give up.
他の具体的な策とか、座禅組むとか、
Any more specific?
他に具体的な対策あるんですか。座禅組むとか、この本読めばいいとか。
いや、私の場合はそういうのはなかったですね。いかにその交流生活の中でも面白いことを探し出すかっていうことですよね。
My tip of advice would be to find something interesting to survive the detention.
いいことか悪いことかわからないですけど、私の場合は刑務官の方をおちょくったりして楽しんでました。
I teased an officer in my prison cells. And that was the amusing part.
Okay, we're running out of time. I'd like to thank everyone for coming today. Usually I think we give honorary memberships to people who come to these PAC meetings, but I don't know where Saikawa-san is, so I'll have to check that. Thank you very much. Can we have a round of applause for all the people who came today? Thank you very much to Mr. Yamagishi, the professor, and Human Rights Watch. We're going to, for the next 10 minutes, we're going to allow you to come up here and exchange business cards with the individuals if you'd like, and then we'll have to clear the room. So please come up. Thank you very much. And adjourned.